Let's suppose the mayor of a city, strike that. Let's suppose the mayor of a city goes to his or her city council and gets a rule freezing rents. You with me?
Yes, Senator.
Freezing all rents
Yes, Senator.
forever and a day. Let's make it even more interesting. Reducing rents by 20%, because housing is a problem, right? Cost of housing. Let's suppose it to try to help people with housing costs, the city, mayor and council, uses its police power under its state constitution as recognized by the federal constitution to say we're going to lower our rents by 20%. And as a result, because of the cost of insurance and electricity and that sort of thing, about half of the landlords in the city just say, look, we're going to have to default on our mortgage. Can this, constitutionally, can the city do that?
What happens when a man nominated for the federal bench is asked 3 basic questions about the Constitution and still cannot give a clear answer? In this tense Senate hearing, John Kennedy does more than challenge a judicial nominee. He turns the moment into a test of legal clarity under pressure. First, it is war powers. Then it is property rights. Then it is race-based classifications under the law. And with each answer, the room feels less like a routine confirmation hearing and more like a live examination of whether this nominee is truly ready for the bench. What follows is not just uncomfortable, it is revealing.
Well, when does the president have to get permission of the United States Congress to use military force?
Well, Senator Kennedy, as I was discussing with Ranking Member Durbin, I do want to be careful about hypotheticals in terms of prejudging.
It's not a hypothetical. I'm asking what the Constitution says. When does the President of the United States have to get permission from Congress to use military force?
Well, generally, Senator, my understanding is the divisions between Article 1 and Article 2 distinguish between the war powers, which are under Article 1 and require congressional consent. Again, talking in great generalities, whereas other use of force, if I understand your question, are things that are likely committed under Article 2 to the President's commander-in-chief powers.
I have no idea what you just said, Mr. Hendershot. Let's try it again. Tell me when the President has to go to Congress to get permission to use military force.
Senator, I think is when, because the text of the Constitution, Article 1, talks about declarations of war, those would be circumstances where the President would, in a general sense, and use of force that is not war under the commander-in-chief power, I think those are under Article 2 without the consultation of Congress.
Okay. I'm sorry, I don't mean to be rude. I just don't understand what you said. Mr. Jones. Let's suppose the mayor of a city, strike that. Let's suppose the mayor of a city goes to his or her city council and gets a rule freezing rents. You with me?
Yes, Senator.
Freezing all rents
Yes, Senator.
forever and a day. Let's make it even more interesting. Reducing rents by 20%, because housing is a problem, right? Cost of housing. Let's suppose it to try to help people with housing costs, the city, mayor and council, uses its police power under its state constitution as recognized by the federal constitution So we're going to lower our rents by 20%. And as a result, because of the cost of insurance and electricity and that sort of thing, about half of the landlords in the city just say, look, we're going to have to default on our mortgage. Can this, constitutionally, can the city do that?
Well, Senator, I think it could depend. I do think the city could have some ability to freeze rents. But I think you would have to look at the
Why isn't that a taking?
well, it certainly could be a taking. And
Well,
I think,
when does it become a taking? At what point?
well, I think it would have to be, you'd have to initially look at the impact, the financial impact on the taking of
Okay.
what could amount to a property.
Let's suppose, that's fair, yes, sir. Let's suppose 40% of the landlords will default on their mortgage. Have you reached the point of a taking or not? And how do you determine when you reach the point of a taking?
Well, again, I think it could depend, but there would have to be a showing that, what the financial impact was. And I
Yes,
think,
sir, I'm sorry, I don't mean to be rude. We just have so little time. I understand that you have to have a showing. Tell me what the rule is.
well, I think the rule is if you're taking property without, the government, I should say, taking property for a legitimate government purpose, I think you can only do that by compensating the owner of the property.
So
Generally,
any freeze on rent is a act of eminent domain? Is that
Well,
what you're saying?
not necessarily, Senator. I think in your hypothetical, you were, at least as I understood it, we're talking about a financial impact, not just freezing it at the moment, but then going on down the
Okay.
road.
In the hypothetical I gave you, who's going to win if the landlord sue the city or the landlords?
Well, I think, again, it would depend on the
You're
length.
not going to give me an answer, are you?
Well, I think it could depend. I know that's a very lawyerly answer, Senator. but I
Yes, sir, it
think-
is,
I
very
think it
hard.
would depend on-
Judge, let me ask you a question in the few minutes I have. Tell me under what circumstances the state legislature can draft a statute that makes a distinction that classifies people on the basis of race.
Senator, I think, Chair Grasso, may I answer?
Yes, and then we'll go to Senator Coons.
Thank you, Senator. I think these circumstances would depend on the specifics of United States Supreme Court
I
case
know.
law and
Just give me
the
some
state
examples.
constitution.
Just give me
at
some
issue.
examples.
Senator, on the basis of race, I think in United States Supreme Court has held that there should be no classification.
No, they've just said you got to have a compelling reason.
That is true, Senator.
So tell me what would be a compelling reason.
Senator, as we sit here today, I cannot give you a compelling reason.
Okay, I appreciate your honesty. Thanks, Mr.
What makes this exchange so powerful is that John Kennedy is not asking obscure trick questions. He is asking for clarity on constitutional principles that sit at the heart of judicial responsibility. And that is exactly why the moment becomes so uncomfortable so quickly. The first question sounds simple enough. When does the president need Congress's permission to use military force? But instead of a direct answer, the nominee gives a layered, abstract response about Article 1, Article 2, war powers, and commander-in-chief authority. Technically, it sounds legal, but politically and emotionally, it fails the most important test in the room. Can you explain the Constitution clearly when the stakes are high and the clock is running? That is when Kennedy cuts through the fog with the line that changes the tone of the entire clip. I have no idea what you just said. And from that point on, this is no longer just testimony. It becomes a live stress test. The second reason this clip works so well is escalation. Kennedy does not stay on one weak answer and drag it out. He moves, he widens the test, he shifts from war powers to a rent control hypothetical, asking whether a city can constitutionally reduce rents in a way that financially crushes landlords and pushes them toward default. Now, the conversation is not only about presidential authority, it is about takings, property rights, compensation, and the limits of government power. Once again, the answer comes back in hesitant, conditional language. It could depend, you would have to look. There would have to be a showing. And that is the point where the hearing starts exposing a deeper conflict between legal caution and judicial readiness. Because yes, the law often depends on facts, but a nominee still has to show that he understands the rule clearly enough to explain where the line begins. Kennedy is not really asking for a law review article. He is asking, do you know the backbone of the doctrine, or are you hiding behind vagueness? Then the exchange becomes even more revealing when Kennedy turns to race-based classifications. At this point, the hearing is no longer about one bad answer. It is about pattern recognition. The senator asks under what circumstances the state can classify people on the basis of race. Again, he is not searching for a perfect seminar answer. He wants a workable constitutional principle. Kennedy even narrows it down for him, pointing toward the familiar standard, a compelling reason. But when the nominee is asked to give an example of such a reason, he ultimately admits that sitting there that day, he cannot provide one. And that moment matters. It matters because honesty is better than bluffing, but it also matters because the admission lands after repeated failures to answer with precision. So the audience is left with a question much bigger than the hearing itself. If this is the clarity we get in a confirmation hearing, what confidence should the public have when the same person is later asked to interpret rights, power, property, equality, and force from the bench? That is why this clip has stronger documentary value than a normal political gotcha segment. It is not just about style, it is about preparedness. It is about whether modern confirmation hearings still reveal anything meaningful about judicial philosophy, or whether nominees have become so trained in caution that even basic constitutional questions now produce fog instead of clarity. Kennedy's style is sharp, impatient, and sometimes theatrical, but the reason it works here is because Thader sees the central issue into plain view. Can this nominee explain what he believes the Constitution requires without disappearing into jargon? That is a question viewers understand immediately, even if they are not lawyers, because it goes to competence, trust, and the basic fear that major legal decisions may be made by people who cannot explain their reasoning in real time. And that is where the outro should land, not on mockery, but on stakes. Because in the end, this hearing was about more than one awkward answer or one senator's frustration. It was about what the country should demand from anyone seeking lifetime judicial power. If a judge is going to rule on war powers, government takings, race, and the limits of state authority, then the public has every right to expect more than polished hesitation. They have a right to expect clarity. So the real question is not whether Kennedy was too tough. The real question is whether the bench can afford nominees who still sound uncertain when the Constitution is placed directly in front of them. If this exchange tells us anything, it is that the most revealing moments in Washington are often the simplest ones, when someone is asked a basic question and the answer never really comes. If you think confirmation hearings still matter, or if you think they have become little more than rehearsed evasions, let me know in the comments. I want to hear whether you think this moment exposed one unprepared nominee or a much bigger problem with the system itself.